Hey guys, welcome back. Joe Brunswick, Insurance Broker to the Stars, making kind of an impromptu video here, hence the wonderful non-business attire that I'm currently wearing. But I saw this popping up and I thought I'd make a video about it. And this deals with mutual vendors stealing your clients or trying to poach your clients. What are some considerations for your MSP? What are some extra things I think you should be thinking about during this process? Now, just a quick search through the MSP subreddit. Is Dell trying to steal customers? Can a PSA RMM steal your clients? Add Huntress to the list of vendors marketing to your customers. Spoiler alert, that got resolved in a really good way. We'll talk about that here in a minute. Public service announcement, Duo Cisco will steal your clients. Microsoft trying to steal clients directly. IT Glue, direct marketing to our clients. This is a guy here at the bottom having a issue with Fortinet. All right, now, when this occurs, I think the best initial course of action is generally going to be to go the pleasant route, right? Which is talking to your contact there at your vendor and saying, hey, heads up, guys, just so you know, this is already our client. We're one of your partners. Could you just tell your sales guys to knock them off the list? Thank you so much. Appreciate it, right? Now, in some cases I've seen, they either apparently don't care, or the word never gets across, or they don't take it seriously, or however that process works with these vendors, it just doesn't seem to happen quick enough, in which case you could consider a cease and desist letter. All right, now obviously seek legal counsel first. As I'm going through this, I'm not your attorney, I'm not giving you legal advice. I'm just the insurance guy. But here's generally what goes into a cease and desist letter dealing with this type of issue. It has come to our attention that you are or maybe tortiously interfering with our contract with client. Now, we're going to talk about tortious interference here in a minute. MSP demands that you immediately cease such conduct, desist from such conduct moving forward, comply with all requirements set forth below, blah, blah, blah. Then it goes on, MSP is amenable to a mutually beneficial resolution. In this case, MSP does not desire to engage in litigation. If we do not hear from you by such and such date, we will, and then a bunch of long words that effectively means we will see you in court. All right. Now, what the hell is tortious interference with a contract, and why should you as a business owner actually know this? Well, it's a common law tort, hence tortious, and it deals with interference with a contract. So once you kind of break it down, pretty straightforward. And it's effectively when one party damages another party's contractual relationship with their client. All right. So i.e., in this case, what we're talking about, vendor steps in, sells the service to your mutual client, cutting you off from that relationship and the potential money that you would make there. Now, general elements to a claim, or put another way, these are the things you'd actually have to demonstrate to try and bring a tortious interference claim in a court of law. Now, obviously it depends on the state. There's nuances everywhere you go. But this is kind of the gist or the general idea of what courts are going to look for. One, there was a valid contract that existed between you and your client. Two, the vendor knew of that contract. And we're going to talk about the importance there here in a minute, because I think that's where a lot of confusion lies. Three, the vendor improperly and or intentionally interfered in your contract without due justification. There could be kind of some niche areas here where they can actually interfere with a contract, but I won't delve too far into that rabbit hole because I don't think you want to go to law school. Wasn't the most fun time. And then four, you have to be damaged as a result of that interference, or most likely what it's going to be is you lost money and or you lost a client because of this. Now, let's talk about those elements here in a second. So a valid contract, that could be your MSA, your SLA, etc. The vendor knew, we're going to dive into that here in a minute. And then improper interference. All right. So is there a non-solicitation agreement that you have in that vendor partner agreement? I don't know. I'm just the insurance guy for MSPs. I'm not the one typically reviewing these vendor agreements. So in that regard, you'd have to see if there's some type of mutual non-solicitation agreement. And is there a lawful competition advantage or pre-existing economic interest? Those are kind of the niche exceptions to the improper interference element. I'm not going to delve too far into that because that's what your attorney's for, but suffice to say there are kind of some interesting reasons why they could interfere, but that tends to be pretty rare. And then damages. Did you lose revenue? How much for how long? Things you would need to document. Okay? Now, I've done too many of these because I already know someone in the comments is going to go, yeah, you could try and sue these guys. You're not going to get anything. It's not with your money. It's going to cost more to sue them than you're going to get in return. That's not necessarily true. Okay? So things you could try and seek. Types of damages: compensatory damages, special or consequential damages, punitive or exemplary damages, attorney's fees, injunctive relief. And then once again, it depends on the state, depends on your circumstances. So talk to that attorney before you just start filing lawsuits. All right. Now, ultimately, we have to ask, and I think this is really where a lot of the confusion and the frustration comes from, is did they actually know that they were engaging in this activity that you think is so heinous? Now, let's look at what I think is probably the master class as far as MSP vendors go in dealing with this type of issue. So a few days ago, there was an allegation that Huntress was trying to poach somebody's client, and then Andrew from Huntress wrote this. All right, so I think this was a phenomenal response, and once again, all hail Huntress. Great job, Andrew, for putting this out there. So he says, hey, this had to do with the 3CX issue. But he goes, hey, it sounds like a contact of your customer somehow ended up on our prospects list. There's no world where we would purposefully market to your customers based on the information we collect, either as you enter them into our system or the services we provide to them. Now, I'm going to go on a limb here. Maybe I met Andrew at one of the MSP conferences I've spoken at, but I doubt it. But I'd also doubt that this guy, I don't think that probably the top of his mind is he's going, hey, we don't want to be sued for tortious interference with a contract. I think he was just in good faith trying to answer this question saying, hey, you know what? This is not what we do. Then he goes on, hey, if you DM me their email address, I can tell you how and when they ended up on that list, and then we can remove them. Right? So once again, I don't think he's trying to weasel out of a tortious interference claim. I think Andrew is like, hey, we're going to do the right thing here. We don't do this on purpose. It looks like the wires just unintentionally got crossed, and so all's well that ends well. So once again, kudos to Huntress and Andrew there. Next, kind of the more boneheaded ways to potentially deal with this, allegedly. All right. So this was an old post. Says Dell trying to steal our customers. We're a small UK-based MSP. Dell just rang us thinking we were the customer's IT consultant. They told us we shouldn't be going through partners. They add margin. Best prices are from Dell Direct. Obviously, we're not happy. That's a rough one. In which case, you may want to get an attorney involved to see what you can do to try and avoid that from happening in the future. Now, this is a really old post, but there you go. This one right here, we had a Meraki rep going after our clients hard. Talked to their manager. He said it would never happen again. Next week it happened, and that's how we became a Fortinet shop. So, this I think is where potentially that cease and desist letter could have come into play, right? So I think probably what happened here is I'm going to assume in good faith that their manager was like, oh, well, shit, sorry about that. They go over, they talk to the sales rep lead. The sales rep lead doesn't necessarily put that information down hard enough or doesn't filter all the way down in a decent amount of time, and then they lost a client there. All right, so that's probably the kind of the more boneheaded way is even when you talk to a manager, it still doesn't get fixed. That could be a cease and desist letter. Now, other causes of action, so you could just start tacking it on, depends on the circumstance. Breach of contract, like if you have a non-compete agreement in there, that could be an issue. unfair competition practices, and fraud. So that deals with false and misleading statements for both those causes of action. Now, what are my personal thoughts here to kind of put a bow on all of this for everybody? Sorry, I'm already at 10 minutes. I didn't mean for the video to go that long. But one, Huntress wins again. So, hey, kudos to those guys. Number two, law of large numbers and benefit of the doubt. All right, there could always be some circumstance where before we go out roasting businesses, some of them deserve that. I will not name names, but I understand where you're coming from. Let's go with benefit of the doubt, law of large numbers. Maybe somebody signed up for a webinar somewhere, and then that person's email address either got purchased or was downloaded somehow. That ended up in the marketing funnel. And so because of that, they're not trying to act maliciously. Maybe they just don't know. All right. So I would encourage people, generally, hey, just reach out to that vendor directly to avoid confusion. And the bonus to that is, one, I think it's just the right way to do business, right? Go along to get along, play nice in the world. The world's terrible enough as is. So go along to get along. But when you're speaking directly, right, make sure you keep that documentation. All right. So if you're sending an email, if you're like, hey, you know what, I'll send you an email with the email addresses that we would prefer that you not contact. That could be documentation you'll need in a case later on if it gets to that point. Once again, if all else fails, speak with your attorney. And then I saw a lot of good comments. So I just wanted to add this at the end here. I saw a lot of great comments in these threads about people that preempt this conversation with their clients. Everything from, hey, you know what, sometimes the wires get crossed and our vendors are going to reach out directly to you. If that happens, just let us know. We'll tell them to stop emailing you so they don't clog up your inbox, right? Or, hey, you know what? Sometimes you're going to get marketing material from any number of like IT, computer vendors, etc. If you could forward that to us, that'd be great because we're always trying to keep track of the latest and greatest going on. So we want to make sure that there's nothing out there we're not aware of that could potentially get you a better deal. All right. So with that, sorry that was 12 minutes long, but wanted to get that out there to kind of, hopefully take some of like the confusion and the anger and the animosity out of this by simply saying, you know what, a lot of these guys probably don't know, but if they do know and they keep going down that path, I think there's some potential legal avenues you could investigate to try and put the kibosh on this. All right, with that, stay safe, guys.